Battle for the AmaZulu King's estate is set to be heard this week in the KwaZulu-Natal Division of the High Court in Pietermaritzburg. There are two challenges. One, the late King Goodwill Zwelithini's first wife, Queen Madlamini, wants to have her civil union declared in community of property that would make hers the only lawful marriage to the king. Secondly, some of the late king's children are questioning the authenticity of the signature on their father's will. This can be classified as a royal mess. Well, to discuss this more with us is Mongezi Guma, a cultural expert, a former commissioner at the CRL. Good afternoon, Dr. Guma. Thank you very much for your time. Now, as a cultural expert, you are most certainly familiar with the controversy and squabbles that follow the death of a monarch. But the issues are mostly centered around succession, one would say. But this particular case of the Queen, it's on her intention to set aside the King's 5 traditional marriages in an effort to ensure that they don't inherit in the same amount as her. But she also wants half of the estate that was held in trust for the Zulu nation. One would say this is a very complex case that will pit common law against customary law. Talk to me about this case.
Thank you. It is a very complex case, as you point out. But just to highlight two things about it. Firstly, it's unheard of in customary law that one of the wives actually inherits 50% of the estate. So that's one of the first things that needs to be settled. And to say that the other wives must share the inheritance with the rest of the children and the family is really unheard of in that sense in customary law. So that's the first thing. And the second thing is that the issue of succession in customary law is embedded in customary practices of the family. Now, when I talk about the family, of course, I'm talking about the extended royal family. And royal families don't just make decisions within the context of the primary family itself. There is something called a royal council that actually also advises on the decisions that the royal family makes. So that the challenge about this case is to try to treat the royal family as a private entity, as between me and my family and so on, which really would set a very disturbing precedence for the family.
Before we talk about the Royal Council and their role in this respect, because it seems the family has now decided to get assistance in the civil court, or at least in the common law space, we must first talk about the first part where you said that this is unheard of, that you would have a wife expecting to inherit half of the estate, and then the 5 are to inherit the other. But when we look at the marriages, the Queen has stated that hers was a civil union and that others were customary. For me, perhaps the interest is to know, insofar as customary marriages are concerned, would there not have been a particular role that the first wife would have played in the ceremony, which would be interpreted as her validating the new marriages, which could be used perhaps in court in this instance as an argument that in fact she agreed through her conduct while the king was alive to these very marriages, so she cannot claim that they shouldn't inherit?
Oh yes. I mean, the fact of the matter is that the king, again, there are a number of issues. Firstly, the king would not have just woken up in the morning and said, I'm marrying a person A, and then I'm marrying person B. Yes, the first wife has a role to play. But again, traditionally, first wives don't beget heirs to the throne, traditionally.
All right.
It is within the context of the nation deciding that we need to have a wife who will beget an heir to the throne. And that is followed with specific cultural practices that would include everybody donating towards the lobola, let's call it. And number two, it would include a decision that is specific to which royal house they should approach to have that wife. Now, all of that is a public discussion. It's not a private discussion between the king and some few individuals, so that the first wife or the second wife or the third wife would actually be part of those discussions, or definitely privy to those discussions. And in terms of your question, she would have an opportunity to oppose those subsequent intentions to marry a wife as anticipated in the Marriages Act in terms of polygamy. But this one is within a context of the Traditional Framework Act.
If you say that the first wife firstly would not bear the heir, and obviously you have just disqualified the whole argument about her perhaps being in a civil union and therefore entitled to half of the estate. But if you're saying the first wife would not bear the heir, why is there a court process now? Yes, automatically. Why then is there a court process? What didn't she understand? Because with us, we then assumed that every culture or every grouping in society, an indigenous grouping, would have its own custom and traditions, and perhaps the Zulu nation has somehow revised its traditions. It's not something that is common cause, that in fact, if you have someone of royal blood, she would be the one that bears the heir. Because we take it that's why everything is going to court, that it wasn't cast in stone. What didn't the first wife know that everybody else would know?
No, she states it. The point for her is that she is the only one who was married by a civil union under the Marriages Act. That's her claim to her right of inheritance.
So setting aside those marriages. So, Doctor, then she intends to set aside those marriages, then essentially saying that her husband never married those other women.
Yes, and she can't do that because she was part and parcel of the subsequent marriages. In terms of, in spirit, even of the Marriage Act, in which, I mean the Polygamy Act, in which we are allowed to have more than one wife. But the complexity in this particular case, it's not just a private citizen who decides to have more than one wife. It is also a monarch who then decides to have more than one wife.
No, so certainly very complex, Doctor. No, certainly a very complex case that one would think will probably be finalized in the Constitutional Court, because in as much as it's a monarch, we're looking now at the recognition of Customary Marriages Act, how it comes to play in this respect. And I know there's another interesting part where in her papers she sought to elevate the aspect that she was actually married at age 20 through the tradition of Ugutwala, and that allowed for the king to ascend to the throne. How significant is the role of that young lady who actually assists or finalizes the process of the king actually being placed on the throne?
The point I'm making is the primary thing is that the royal house and the nation decides who will beget an heir to the throne. That's the first thing. Now, that particular wife might actually have more than one child. And then the second level about that decision is then who amongst those children will then inherit the throne. In other words, many of us watch too much TV and then want to transpose on traditional practices what really doesn't belong there. It's not part of the argument.
No, it's most certainly an opportunity for all of us to learn, Doctor. And I apologize profusely. I wish we could talk a bit more on this conversation, but unfortunately we have run out of time. Hopefully we can have you just before Wednesday when this matter is to begin in court. But thank you very much for your time.